Welcome to Risk, Liability and Litigation with Kevin Mayer.
Welcome to Risk, Liability and Litigation with Kevin C. Mayer, partner at Logan Mayer LLP in California. Kevin is a seasoned trial attorney who helps businesses navigate complex legal disputes, regulatory challenges, and high-stakes litigation when the risks are significant and the outcome matters. I'm Lisa Mosbey, and today we're talking about what companies should do in the first 24 hours after an OSHA investigation begins. Welcome, Kevin. Thanks for joining me today.
Lisa, it's a pleasure to be with you today.
Kevin, to start, can you tell us a little bit about your background and the kind of high-stakes litigation work that you've handled throughout your career?
Sure, I'd be happy to. I've now been practicing for 42 years. I started my career in San Francisco and then in 1997 was dragged kicking and screaming down to Los Angeles with one of my prior firms. I spent 38 years in the big law environment, going from uh, California-based firms to Pacific Coast-based to national and then international law firms before we started Logan Mayer in 2022. The vast majority of my litigation and trial experience in the course of my career has been in what we call toxic tort, environmental, and OSHA litigation and trial. So when we talk about toxic tort, we're typically referring to personal injury and wrongful death cases from exposure to chemicals and substances that are considered to be hazardous to humans. The environmental piece was usually what we call gunk in the ground and in groundwater from various sources. Could be petroleum hydrocarbons, could be chemicals, could be a variety of substances that are said to damage soil and groundwater. And then the OSHA piece, of course, which is what we'll be talking about today, is, as the name implies, occupational safety and health. And in that regard, my practice has been really a soup to nuts practice, handling compliance counseling, internal investigations, incident investigations when things happen which cause the OSHA investigators to show up. And then if citations are issued, to appeal those citations, try to negotiate their resolution, or if necessary, try them to an administrative law judge.
And Kevin, if a serious workplace incident happens and OSHA gets involved, what should company leadership be focused on immediately?
So a company should always plan for the worst in advance. They should never wait till there's actually an incident where something explodes, somebody falls off scaffolding, somebody gets hurt or killed, or property is damaged in an incident. All of that should have been planned for well in advance. And indeed, the OSHA regulations typically apply to any company that has 10 or more employees. That's true at both the federal and at the state level, because every state has an OSHA program. It's either its own program that has been approved by the federal government, or they simply adopt the federal OSHA program as their own. And so companies need to have a variety of mechanisms in place to comply with the OSHA regulations so that at the time an incident actually occurs and the OSHA investigators show up knocking on your door to investigate that incident, you're ready to go. And principally, what leadership should have in place is part of their team who are devoted to working with not only the OSHA personnel, but conducting their own internal investigation and interviews, typically in an attorney-client privileged environment. So they don't have to have any concern necessarily about upper management being exposed to voluntary discovery with the OSHA investigators that they don't have any control over and don't have any ability to influence at the time.
And Kevin, how does early employee statements affect the company once OSHA begins investigating?
So we draw a distinction here between company employees and management and supervisory personnel. And the interesting thing about OSHA investigations are that while the company can have its either in-house attorneys or outside counsel sit with management and supervisory personnel when they are being interviewed by the OSHA investigators, that same opportunity does not exist with regard to line employees, people who are not management or supervisory personnel. They can be interviewed by OSHA investigators without counsel being present, without management or supervisors being present. And the idea behind this is that OSHA will tend to get more honest information from the employees if they don't feel perhaps intimidated by the presence of their superiors or by the attorneys working for the company.
Sure, I can understand that. So, what should companies think about before allowing OSHA inspectors access to the site or internal information?
Well, so what happens is when an incident occurs where there is a reporting obligation to OSHA, somebody is seriously injured, taken to the hospital, somebody dies, there is a major incident that results in property damage. It could be an explosion at a refinery. It could be somebody falling off a ladder while screwing in a light bulb in the lobby of your office building, and everything in between. The employer has a reporting obligation to OSHA when those sorts of things occur. And in response to that, OSHA will typically, within 24 hours and often quite a bit less, show up on your doorstep ready to commence their investigation. And when they do that, they will typically be asking the employer for a variety of documents and logs that the employer is obligated to maintain under OSHA regulations with regard to workplace health and safety issues. That could include incident logs, OSHA 300 compliance, anything that they may have developed independent of attorney-client privilege for OSHA compliance and investigation of the particular incident. And so it's very important for management to understand that when OSHA shows up, it's really not up to you as to whether they are allowed admittance onto your premises. They are allowed to be there to conduct the investigation for which they receive notice. And what you have to be aware of as an employer is that the OSHA investigators aren't just going to ignore anything else that they might see or hear about in the course of that investigation. So while they may be there to investigate incident A, if they see evidence of violation B, C, and D, even though they weren't there to investigate that, they're going to look at that as well, and you may end up getting cited for it. So employers need to be aware that OSHA has pretty much free rein when they show up to do an investigation. And you will want to obviously keep them focused on the purpose for which they are originally there, but understand that they're not going to ignore anything else that they see that could be a violation of occupational safety and health regulations.
And I know, Kevin, you're saying keep them focused on what it is that they're there for, but how should companies think about cooperating with OSHA while also protecting themselves from future liability? What can they possibly do?
It's an excellent question. And so this is where the companies need to have a good relationship with either an in-house attorney or their outside counsel who are responsible for overseeing and helping to guide their OSHA compliance program and also assisting them in conducting their internal investigation of the incidents or anything that they are looking into in order to ensure that they're complying with OSHA regulations. Because OSHA likes it when employers cooperate with them. The employers that are going to get the greatest scrutiny are those in two areas. One, where incidents are constantly occurring. And the joke that we have in the industry is that OSHA has season tickets at some of those facilities because things happen so often and with so much frequency, and they can be very dangerous. Or a situation in which an employer has acquired a reputation for being uncooperative with OSHA. That is never a good thing. You want OSHA to be an asset that you can call on. Because after all, what is the purpose of the OSHA program? It is to ensure the health and safety of employees and others who are on the employer's premises. And so the employer, acting in good faith, should have every reason for wanting to have a cooperative relationship with OSHA while at the same time being able to conduct their internal compliance audits, their incident investigations, and things related to that under the protection of attorney-client privilege and attorney work product.
Having a good relationship and open communication with OSHA makes complete sense. But when does an OSHA investigation start becoming more than a regulatory issue and turn into a larger litigation risk for the company?
It's an excellent question, and I'll give you a really good example of how that works. Several years ago, we were handling an incident at a recycling plant in Southern California. And in that incident, a very experienced employee, for some reason, was walking outside the yellow lines that demarcated where they could be walking in the yard. He wasn't paying attention. And then a skip loader was backing up in the yard, had its blinkers on, had its beeper on, so that everybody knew that this was a machine, heavy machine that was backing up. But for whatever reason, the employee didn't see it, didn't hear it, and he got run over and killed. Fatality incident. OSHA has to be put on notice virtually immediately. OSHA showed up within 6 hours to commence the investigation. Out of that, we had three different things that we had to contend with. One was the OSHA investigation. One was a criminal investigation that the district attorney's office in that county initiated. And the third was civil liability that the plaintiff attorneys representing the deceased employee's family wanted to bring. And what happened in that circumstance is that the DA told us flat out, you're going to resolve all three of these matters at once, or I am going to indict your executives. Well, if you're a corporate executive in a situation like that, and yes, you're dealing with an unfortunate circumstance, the last thing you want is to be threatened with criminal exposure, potential criminal penalties, which could include imprisonment, arising out of such a circumstance. So needless to say, the company took that advice to heart and all three of the matters were resolved. That is an unusual circumstance, but it is not unheard of, because one of the things that is happening today at both the federal and the state level is that often there is a cooperation agreement between the OSHA investigators and the criminal prosecutors if a particular incident rises to the level of potential criminal misconduct. And in that circumstance, the company can be in a whole world of hurt if they don't take those things seriously and try to get them resolved.
Thank you for tying it all together in a picture and an image and in a live case, because I think that really does impact people who are listening to bring it home to really understand the importance of these rules and what OSHA actually does for us. Tell me, Kevin, have you ever handled situations where a company's response in the first 24 hours had a major impact on how everything unfolded afterward? And how important are those first 24 hours?
It's absolutely correct. The first 24 hours are critical in any investigation because not only are you dealing with the OSHA investigators who are on site interviewing your various personnel, management supervisors, and line employees, but any sophisticated company who has been through this should be conducting its own internal investigation. And typically, we find that companies that are involved in high risk engagements, oil refineries, chemical manufacturing plants, electrical plants, etc., they will have a root cause investigation that they initiate very quickly after any incident because it is in their interest to identify the cause or causes of this incident in order to take remedial steps to try to ensure that this kind of thing can never happen again. And the more that OSHA sees that the company is taking these sorts of things very seriously, the more likely it is that you will be able to negotiate a reasonable resolution of the problem. And that doesn't mean you won't get cited. It doesn't mean OSHA won't issue citations, and some of them may be classified as serious because they have no choice based on the effect of what happened during the incident. If people die or people are hospitalized, property blows up, things of that nature, you're facing serious citations. But the issue may become how many are you facing and what are the odds of resolving those short of going to trial in front of the administrative law judge. Now, by contrast, I have had to deal with companies that treated OSHA as, if not a suggestion, certainly an inconvenience. And this rose to the level of upper management where they frankly didn't care. And they were running a bet that they could get away with, I won't say murder, but get away with their rather cavalier attitude toward compliance with the OSHA regulations. That invariably does not end well for the company. And indeed, it could put a target on their back for a long time going forward.
And how scary for employees that work for that company to know that their health, safety, and their lives don't matter to their company. It's a pretty sad story in a corporate America.
It's really true, Lisa. I mean, we've all heard the argument that plaintiffs' attorneys like to make about certain companies: profits over safety, profits over health. And that is a good example when you're dealing with a company that does not take its OSHA obligations seriously, because they don't want to spend the time, the money, the resources in order to ensure that they're running a safe and healthful work environment.
And we'll leave it there for today's episode. I want to thank you for your insights and walking us through this and really bringing our attention to how very important and significant OSHA is for all companies to be paying attention.
Thank you so much, Lisa. It's been great speaking with you.
Thanks for joining us for this episode of Risk, Liability, and Litigation with Kevin C. Mayer. If your business is facing complex litigation, regulatory investigations, or other high stakes legal challenges, you can learn more at loganmayerllp.com. Be sure to like, leave a review, and subscribe to the show so you don't miss the next one. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.